Okay, we're going to pick up, and I'm going to start just a little bit before the sovereign citizen walks in, because what I want you to hear is the fact that there's nothing else that happens before this interaction. It's not like I'm jumping in the middle of this, because remember, we're going to talk about how the judge reacts to the way that this sovereign citizen steps in.
All right, appearances for the people versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have works.
Yeah,
You're on Friday.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir.
Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry. Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely.
Okay, we're going to pause it right there, because what we just now heard was the sovereign citizen steps in. So we've heard everything from the very beginning, from the very first interactions that the judge had with the sovereign citizen. And so you can hear there hasn't been, I mean, the sovereign citizen hasn't said anything negative or harmful. Judge is being very curt here. What are your opinions? What are your thoughts on the judge's demeanor from the very outset of this? So far, this is my thought. So far, I think the judge is just being very curt. He's taking control of his courtroom just like he needs to. Judges have a responsibility to make sure that the system of justice is being carried out in a very equitable manner, and also in a very efficient manner. And so I don't fault him yet to this point. I think that he is obviously irritated at the outset, but let's continue.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on a record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's.
Oh, by the way, I did not warn you that judge uses some naughty words during this hearing. So if you have sensitive ears that can't handle naughty words, plug your ears now, because that's not going to be the last one. So let me ask, what are your thoughts so far And that's where we're going. As you can see, the judge started off a little bit irritated, and you can see that I rescue dogs. Yeah, he's judge has not got no patience even from the outset of this. Yeah, Adam, we don't yet have our commands set up. I'm still working on that. I thought that I did, but we'll make sure we set up a content warning command here pretty soon. So you can tell Judge's temperature is just steadily rising as this thing progresses. But what do you think so far? Thumbs up. You think the Judge is right for how he's acting so far and his temperament so far? Thumbs down if you think the Judge is already starting this thing off on the wrong foot.
That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
you have a jurisdictional argument you want to make?
Well, I've served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that?
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
Ooh. Now, how do we feel about how the judge is reacting so far? And by the way, I just now got a pop-up, Crystal, that said that commercials that just now run. Sorry, I'm still learning on these streams, and so I'm going to pause for just a moment. That way you can get back to us and you're not missing anything from being gone on the commercial, because that was a big part to miss. If you missed it, the judge just now told the defendant to shut up while the defendant is making an argument to the court, because it sounds like the defendant, the sovereign citizen here, is discussing jurisdiction. He's making some of these very typical, these are not new, very typical sovereign citizen arguments. We haven't heard the phrase subject matter jurisdiction yet, but it feels like we're on the verge of it. It feels like that's coming up really, really soon. So Bad Squirrel decision, Bad Squirrel decision says he could have a little bit more patience. M and B, you're still fine with the judge as he is right now. All right, let's keep listening.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party. Who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the state?
Sir, sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one. All
I see.
right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge.
All right, so all of that just to finally get the defendant up to counsel table, so that way he is properly before the court. And so he, the judge said, I am calling for Mr. So-and-so, and I didn't catch his name. Judge called for the defendant. Defendant said the typical sovereign citizen garbage of I'm their representative. And so judge said, look, if you're him, then you need to step forward. But judge is absolutely, he's biting at the bed on this one. Ricky has got it spot on. And Kempers, you're right. Sometimes the judge has to be very stern in order to get this shut down, because what he's doing is even though, just like Chad says, the defendant said he's not a sovereign citizen, but he's acting in the same way that we all know sovereign citizens to act. And whether or not they call themselves sovereign citizens anymore, because it's contradictory. Even whether or not they call themselves sovereign citizens or not, that doesn't matter. We all know the class of people that we're dealing with, of people who think that the law doesn't apply to them. But they still have that right to make that argument. I'm not going to stand here or sit here and say that they don't have a right to make that argument. However, whenever he makes that argument and the judge rules on it, that's how the legal system works. If you don't like the judge's ruling, then your options are to appeal it. You can't continue to argue with the judge after the judge has made his ruling. So let's go back, or not go back. Let's continue here.
Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said?
Ooh, we might be a little bit over the line here on that one. Let me chat. You guys tell me, what do you think? You think that Judge is over the line? Because he's used a very clear he used the S word. You think that's over the line here? You think the judge has crossed any lines? Think the judge has violated any sort of judicial canons yet? I want to know what you guys think. Give me thumbs up. You think the judge is in the right? Judge has done no wrong yet? Give me a thumbs down if you think that, nah, that really was not, no, that wasn't called for. We'll keep listening.
I'm waiting for an answer.
I said, I object. What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also.
Okay, we're going to hit pause right there because it's about to get a little more elevated. And so Amber's showing up to the party. Amber, I appreciate you being here. Let's see. Oh, I'll fix that in a minute. So before we move on, there's something that I want to cover with you that I think that you because I want to make sure that we don't just watch this judge and me give you my opinion on it. Yeah, Adam, it's going to get a lot more elevated than that. What I want to do is I want to show you the law, because what we're doing here today, and the reason that we're asking these questions is that I want to make sure that you guys know what to expect whenever you're in court, because this defendant, I mean, he very well may have just read all of this whenever he was, sitting at home one day. And so this might be the script, the prepared script for sovereign citizens to go into court and to argue. Or it very well might be, and so this very well might be his first time in court. Right now, we don't know the answer to that. So what we're going to do for just a moment is we're going to talk about what to expect in court. So let's talk about those judicial canons for a moment. So this is Michigan. This is the Michigan Code of Conduct. Sorry, Adam, if it looks like I'm looking up on the my bat screens here. The Michigan Code of Conduct, Canon 3. A judge should perform the duties of office impartially and diligently. And if you notice here, Judicial Canon 3A3. A judge should be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals with in an official capacity, and should require similar conduct of lawyers and staff, court officials, and others. Sorry, my cursor's all over the place. And court officials and others subject to the court's direction and control. What do y'all think? What do y'all think about the judge's actions so far of what we've seen? Do you think that the judge has been reacting in this case so far patient, dignified, and courteous to the litigant. So as we continue, that's what I want you to focus on. That's what I want you to listen for is the judge being patient, dignified, and courteous?
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
Because you
have my due
didn't give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr. Michaud.
still, on this. it
Mr.
doesn't-
Michaud,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing. or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There-
And in order
There's no
to prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony. where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Okay, listen. You can't tell me something and then just disagree with me and think it's, listen to me, sir. I am not going to let you interrupt me.
Okay, let's pause that for just a moment because we can see that, yeah, judge is getting a little bit aggressive. So what you hear the defendant asking there are about the bonds, that judges have certain bonds, or there are these other special types of bonds. He listed a few of them there. I don't remember exactly what he named them, but that's something that common that you see amongst the sovereign citizens, is that they say that they want to see that bond. And so that's what he's trying to do right now, is put the judge on the spot and demand to see those bonds. And I think that y'all are kind of seeing that a lot of the same thing that I am, is that unfortunately that the judge is at times cutting off the defendant. And so the defendant is also cutting off the judge, but the judge should patiently stop the defendant, say, you, sir, I'm speaking, let me finish my statement. And by the way, as attorneys, one of the easiest things for us whenever, you know, opposing counsel or the witness starts trying to talk over us is we say, oh, hold on. The court reporter cannot type down both voices at the same time. So you have to stop so that way the court reporter can type down one at a time. And so I see times in this so far where the judge is cutting off the defendant and the defendant is cutting off the judge.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a.
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great, then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It does, it should mean something
Can
because,
you prove it? Please prove it.
can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so.
Hold on, you've asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
You proved it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay?
you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen to me. Mr. Michaud,
you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's.
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days.
30 days.
I don't think we're gonna use you today. Have a good day. Be safe. Good to see you, John.
Property-wise, you want to give to your wife, sir?
Hey, Ryan, let me know what the next one is.
Is this okay that I give this to your wife?
Yeah.
Yes, yeah, your wife.
Take mine.
John, ask the wife to come in so he can see his property go to his wife.
Thank you, Judge.
It should be the Jackson.
All right, so what we're going to do is we're going to go back, we're going to talk about what it is that we just now saw. And then now I want honest opinion from you. You tell me, honest opinion. Was the judge patient, dignified, and courteous to the litigant? So go back to the very, very beginning. Let's start it back at the very, very beginning of the, still no audio? You don't hear anything from me? Oliver, you can't hear me right now? How about now? Okay, so y'all can hear me. So let me ask this. Was the judge patient, dignified, and courteous with the defendant? Because that's the obligation right there by the judge. The judge must be patient, dignified, and courteous to the litigant. Now, litigant was making some ridiculous arguments, but also they're ridiculous only because we know what the law is. The litigant, the defendant here, he was making what he thought were reasonable arguments. He was asking the judge things. And if you go back to the very, very beginning of the clip, whenever we first started, remember what the judge told the defendant was, I will give you an opportunity to make your record. I'll give you an opportunity to put anything on your record on the record that you want. Yet then whenever the defendant was attempting to put these things on the record, what the judge did is what we saw is the judge started arguing with the defendant and started telling him why he was wrong and why none of these things existed. What the judge should have said is, sir, I'll let you make your record as soon as we're finished. I will save you for the end. Or he could have very well said, sir, I'm going to save you for the very last item on the docket. That would have given the judge a little bit of time to cool down. And so saved him for the last item on the docket and said, sir, we're going to work through our docket. I'm going to work through this preliminary hearing or this probable cause hearing. And so at the end, anything that you want to put on the record, I'll let you put on the record. And so the judge, whenever we put things on the record, sometimes it's not necessarily with the judge sitting there on the bench. So whenever you make your offer of proof, sometimes the judge isn't even sitting there. Whenever it's a jury trial and I want to make an offer of proof because the judge has decided to exclude all of my evidence, I don't make that offer of proof as to the excluded evidence while the jury is sitting there. And so I just need it to be on the record so that way the Court of Appeals can consider it. So yeah, he should have held him, what I think is he should have held him towards the end and then given him plenty of time to put anything on the record that he wanted to put, just like the judge promised. But instead, what did we hear? So what we heard is, I Rescue Dogs, fantastic point. Give him 5 or 10 minutes to get it all out. I mean, I know that the judge has a busy docket, but you know what? That's the reason we build courthouses, is so that way we can have these hearings. And so the judge should have told him that, all right, I'll allow you to put whatever you want on the record, or just asked him to submit a written motion as to what he wanted. So that way it was very clearly on the record. And so instead of the judge just simply saying, okay, I understand that you've requested that request is denied. All right, I understand you've requested my, what was it called? Indemnity bond. You've asked for an indemnity bond. That request is denied. The judge could have just point by point added those in there. All right, sir, I am understanding that you're asking for an affidavit. That request is denied. Because even though there was a sworn statement, the probable cause affidavit, what the defendant was asking for was more than just a probable cause affidavit. The defendant seemed to be asking for an affidavit from the injured person. So, in this crime, it's the state that's the defendant. The state is the one who's been harmed. So then the judge allowed himself to get angrier. He started getting even more upset. You heard him. He told him, get your ass up here and sit down. I mean, whoa, judge, is that language dignified? Is that courteous? Because throughout the entire hearing, we never once heard the defendant use any sort of swear words towards the judge. We never heard him, much less even cop an attitude. He was making these arguments. Maybe there's one point where where the defendant reacted whenever the judge said that he was or told him that he would hold him in contempt. And so the defendant said, wow, another threat. And the judge said, yeah, and there are going to be a lot more. And so that little reaction of, wow, was about the most that we heard from the defendant. And so the judge, I mean, in this instance, this is one instance, this one hearing, the judge didn't react with the same courtesy that the defendant was offering to the court. Because let me ask you this, how would the court have reacted had the defendant used the exact same language that the court was using? I'm willing to bet that the court would not have been quite as kind to the defendant as the defendant was to the court during this. And so here's what you might not realize is that, and this is what we're covering in Thursday's video. So if you haven't subscribed, I'd ask you to consider subscribing so that way you don't miss our videos. But the video that we're covering on Thursday is going to go a lot more in depth than what we're covering right now. This is just a little bit of a sampling, because here's the downside is that what we're about to talk about for the kind of the preview for this coming Thursday's video is what unfortunately very well might happen to this judge that we just now watched. Because as you can see, a judge should be patient, dignified, and courteous to the litigants. And so you might be wondering, all right, what happens to a judge if the judge isn't courteous and dignified to the litigants? Well, you know, what happened in this video that's coming up on Thursday, let me answer this first. Bodie, this was the court's live streamed YouTube channel, which is still live right now. That's what I just now played. That's comes straight from the YouTube channel, and it's still live. You can go watch the entire hearing. And I haven't watched more than just this one hearing to know if this is the way that this judge normally acts. But how do you think that the Michigan Supreme Court would handle the judge that we just now saw in that last case? Because in my opinion, it looks like the judge was acting less than dignified and courteous. And so given with the way that we saw that this judge was treated, do you think that we'll see anything different that might happen to this Michigan judge? So I want to see what questions you guys have about, and also what your thoughts are on how that judge treated that defendant, even though we can all agree that he was making some ridiculous arguments in that, you know, the typical sovereign citizen arguments. Do you think that that we're going to see this judge get punished the way that we saw that Florida judge punished? What we're going to cover on Thursday is going to be a judge who acted a lot more indignant in court and a lot less courteous in court than even what we saw today. What questions do you guys have? Bodie, if I'm pronouncing that right, Bodie, you're right. Nobody has time out there to simply watch over the judges, because you've got appellate court judges, but they aren't necessarily the supervisors of these trial court judges. There are administrative judges or judges over the administrative regions that supervise, but there are so many hearings every single day, and those judges are also handling their own dockets. So they don't necessarily have the time to police this on a daily basis. And so the way that this usually happens, the way that they get corrected, I'll say, is whenever someone makes that report. Now, and by the way, I'm not promoting that that anybody go out there and report this Michigan judge. That's not the point here. But that's the way that these things get handled, is by a report. Honestly, most of the judges that I know, if they feel like they've overstepped a line like that, because I've seen a judge overstep the line to me personally. And the very next day, he called me on the phone and he asked, Matthew, I feel like I was out of line with you yesterday. I feel like that I wasn't acting very courteous. Do you have a minute to come visit with me in chambers? And so, I mean, the case was over. We weren't talking about the case. He just brought me in and he said, I could have done better. I should have been a little bit more patient. I know that you were just arguing for your client, and I just ask you to forgive me for it. And you know what? That meant a lot to me as a young attorney, because I had only been practicing a couple years at that point. And so that meant a lot to me to know that a judge could humble himself the way that judge did, and let me know that, like, that's not what I should expect as an attorney. And that really made an impression on me. Adam, fantastic questions. What sort of options do higher courts have short of a public reprimand? So rather than a public reprimand, they can require, and this is what you'll see on Thursday, is they can require additional education. They can require meetings with mentor judges. They can also do private reprimands. They don't have to make this public every single time, but sometimes, depending on the severity, that's the only option. Let me tell you, it's not that judges are worse now due to more cameras. It's that now they're more publicized. And so we're seeing them instantaneously. They're live streamed on YouTube. And so we see the judges' actions almost in real time. And then on top of that, you have all these other people, just like for my friends here from Scott's channel over at Recovery Addict. Can someone put a link for Recovery Addict so that way anybody else that doesn't know who I'm talking about, you can go and find Scott, because if you like watching live trials, Recovery Addict channel is just the absolute best place to be. It's not that, so whenever you have these people who are live streaming, it is immediately preserved. So it's not just the court's channel who has the ability to delete it after the fact. It's immediately copied and recorded by hundreds of other live streamers out there who are reacting to it and responding to it. And so I think that's the difference here. Problem is that it's a lot more publicized. But remember back to what I said in the very beginning, I'm a big proponent of it. I'm here for it. I think that light is the best disinfectant. So Brandy Churchwell, she's another fantastic live streamer for true crime trials. So if anybody can post the link for Brandy and Scott's channels, that's something I'm working on, are my commands, and Brandy and Scott are on the top 2 of my list for some of their commands. So if it feels like that it's getting worse, I don't think it is necessarily getting worse. In fact, I bet you that it's getting a little bit better, because all the judges know that it's going to be put out there, and they know that the public has a lot more opportunity for reporting them versus prior to the pandemic. Abel asks, how would a public reprimand affect the judge's credibility? You know, I don't know that it necessarily affects the judge's credibility, at least credibility for truthfulness. It's probably going to affect the judge's credibility for running an efficient courtroom. And that Florida judge that we just now saw, he lost the very next election. And you have to imagine that public reprimand on YouTube had to have played some sort of part in it. So those are my thoughts. That's the video that we were finally able to cover, and I'm glad that we were able to look at a couple of those judicial canons. I'm not going to stick around all night long. I know that y'all have got better places to be than watch me fumble around and learn how to live stream over here in real time. So, oh, you're right. Oh, it absolutely hurt the Parkland judge. Here, let me see if I can get some links here. And then we're going to conclude at that point. All right, there is Recovery Addicts channel. And then Brandy Churchwell, the 13th juror. Oh my goodness, look at this. Scott, the man, the myth, the legend, appears in chat. See, if you say his name 3 times, he appears. It's kind of like Beetlejuice. So, that's it. That's the show for today. That's what I have. I appreciate all of you tuning in. I appreciate you listening to me talk about some judicial ethics. It's the most exciting thing that I could think to cover right now. If you haven't subscribed, I would humbly ask that you consider subscribing. And if you liked what you saw here, if you liked the video that we covered, there's more of that to come. We're going to have more of that covering on the channel. We're going to cover more of that in live streams in the future. And I'm going to do my best to answer more questions in future live streams. That's it. Be educated, be kind to everyone, learn your rights, because if you don't protect them, nobody else will. Thanks, y'all. Have a good night.